Thank you, Mr. Chairman.
You're welcome.
And thank you, ladies, for being here. I want to say two things right off the bat. First off, I'm not an attorney. So just listening to the conversation back and forth, very interesting to me as a non-attorney trying to figure out a way to make sure that the people in this room and the people that may watch this hearing can understand all of the dialogue and the terms that we are using. And I thought we might start by saying or clarifying a couple of things that we've covered already. And I also want to say that, which has been said many times by folks already and will be said countless times today, there is not a single person in this room that is not concerned for the victims of domestic violence. There is not a single person. And I'm upset about this legislation for a lot of reasons, and we'll get to that in a moment. But the one thing that will make me very angry is if anyone implies in any way that someone opposed to this proposed legislation does not care about the victims of domestic violence. So, just getting to my point. We talked about what ex parte means, and I believe you stated that it means not necessarily that there'd be another person there. And I just want to clarify that ex parte actually means one-sided, and there is no other party. It's only the accusation of one person, right?
That is correct.
Okay. And the other thing is I share your concern about that 14-day window between the time that the ex parte is asked for by an applicant and the time that the hearing is granted. I share that concern. In fact, we had a press conference the other day to talk about possible ways to shorten up that time frame to get folks in front of a judge so that we can get a resolution. I just thought it was interesting that it was a 14-day window that's so dangerous, except when we were talking about the applicant's rights, and then it was, well, maybe not be 14 days. That's the outside range. So is it 14 days, or could it be less?
Of course, it's up to the judge to be able to call it.
Understood. But it's not always 14 days that
No,
we're
that's-
putting someone in danger. That's all. I just wanted to make sure that that's very clear.
I think, as Attorney Buckman said, it's the maximum is 14 days.
Right. The current law requires that a hearing take place before someone's firearms have to be turned over. Is that correct?
That is the current statute.
Right.
Correct.
Do we know why that is?
I am not familiar with the legislative history of the particular ins and outs of that law.
Do we think they could have something to do with our U.S. and state constitutions requiring due process of law?
Representative Sampson, we believe that what is being proposed right now is due process, has due process, because it is going in front of a judge.
Well, I'll just read Section 8 of the Connecticut Constitution, and just for the edification of the people in the room, and we'll see if this actually constitutes due process. No person shall be compelled to give evidence against himself, nor be deprived of life, liberty, or property without due process of law. That's right there. It's in our state constitution as well as the U.S. Constitution. Yes, I understand. Can I ask, this question was asked before, but how many of these ex parte restraining orders, which are granted by a judge, only hearing from someone making a statement and never ever seeing the respondent, the so-called abuser? So how many of those actually, upon the hearing at the 14 days, become permanent restraining orders? I appreciate that. Forgive me that I'm surprised that we could be having this discussion and not be prepared enough to know exactly how many of these people that were so concerned to have their restraining order on the first day to apply for it, that they may not show up for the hearing even after the 14 days, and many of these get thrown out. I think it's an important statistic for people to know before we start making a determination that we're going to take people's rights from them. And that goes to my point. Is it always the case that the applicant for a temporary restraining or ex parte restraining order is the victim?
The judge decides that. When they go up there, the judge will decide if there's really a victim.
Yeah, I appreciate the concern, Madam Lieutenant Governor, and I mean no disrespect at all, but just because someone files an application for a restraining order doesn't mean anything in my eyes. I mean, we've not heard from the other person. We don't know what their side of the story is. How can a judge make a accurate determination about what's really going on and who's potentially in danger because one person says the other person is?
I believe this is what goes on all the time. It has been going
Right. My feeling is that the due process of law exists for this express purpose. It's that, your proposed bill, we're just taking out in brackets the words "and an opportunity to be heard." I mean, it's pretty bold if you ask me. We're just going to take that part out before we take someone's firearms. And I think that's in there because due process requires us to give an opportunity to that person to be before a judge so he can say, well, wait a second, I know that this person is making a claim against me, but who says it's valid? So I guess my question, very simply, is it always the case that the person that is applying for the restraining order is the victim? It's really a yes or no question. And the reason why I'm asking is because is it possible that someone might request a restraining order for some other purpose than because they're a victim of domestic violence? Maybe they might be doing it because they're trying to punish someone that they're upset with over a relationship issue or a job issue. Is that possible?
The application is a sworn statement, so if somebody were doing it where it was untruthful, then they themselves would be subject to criminal prosecution.
Understood. But we have due process in this country which prevents people from being prosecuted or being punished until they get their side of the story. Just because someone claims that something was committed against them doesn't say it happened. And that's the reason why this protection exists. An opportunity to be heard is the opportunity for the judge to say, wait a second, we shouldn't take this person's property away from them just because of someone making an accusation. I don't want to take the committee's time here. I think I made my point that it's not always clear. There are many, many circumstances where both parties file against one another. There are circumstances where people file as retribution for some other thing. There's no guarantee that the person who is the applicant is a victim, and that's what I want to talk about. Really, more than anything, I want people to realize we're not talking about necessarily victims. We all are concerned for victims of domestic violence, but an applicant for a restraining order does not define a victim. That happens after there's a hearing and people get an opportunity to be heard, which is why that's in the law. Can I ask what happens to the person's firearms once they are taken? Do you have any statistics about how soon they are returned? Assuming even in permanent restraining order situations these days, when someone's firearms have to be given up to the court, how fast do they get them back?
I apologize, Representative Sampson, they were dealing with the microphone, so could you repeat your question?
Understood. I'm just curious to know, under current law, if you have a permanent restraining order, after the hearing, and it's determined by the judge that your firearms need to be taken, at what point does that person get their firearms returned to them? And more important than that, how about their permit?
Well, the restraining order would have a length of time associated with it. The issuance of a restraining order prohibits you from possessing a firearm, so your permit would be revoked at that point in time. And when the period of the restraining order ends, you would be free to reapply to obtain that permit.
Understood. Do you have a time frame that typically happens?
I do not. That's the Board of Firearm Permit Examiners that handles that, and it would be in the normal course of business.
Yeah.
For
I asked the question of folks that are on that board, and they told me it takes 2 years. So someone could today, under current law, when this is a problem we ought to resolve, apply for an ex parte restraining order. They go to a hearing. It's determined that the firearms are taken away, and they don't get them back they don't even get their permit back for 2 years. This legislation, if it passes, that would mean that happens based on someone's one-sided argument and claim that has not been determined to be valid at a hearing. And that person, even if they're completely exonerated, the person who applies for it doesn't even show up for the hearing. They resolve their differences, whatever happens. But the fact is that person's out their firearms and they're out their permit for 2 years. I go back to this is why we have due process. All right,
Again, Representative, there is due process in this process.
well, I think that's for a court to decide. And I think it's quite clear from reading the statute that that's why that was included in our original law. Did I hear when I came in, by the way, I came in the middle of your testimony, I'm sorry, that you stated that 20 other states have similar legislation?
That is my recollection.
All right, understood. Do any one of those states, or do all of those 20 states, have a process by which someone's property has to be surrendered without a hearing?
Again, that was a question that was asked earlier, and I indicated that off the top of my head, I don't have those statistics or that information, but we certainly will be happy to provide it.
I'm quite confident there isn't any, and it goes back to the same case. All right, thank you very much, and I appreciate you ladies' time. I sincerely appreciate the dialogue, and I don't want anyone to think that somehow I'm not concerned about coming up with positive solutions. Again, from the top of this, I'd like to find a solution. I think the solution to this is to actually get the potential victim in front of a judge right away. In my mind, if something is so dangerous that it would require someone's firearms to be taken away, I think that the person being accused ought to be arrested immediately. And I'll just leave it at that. Thank you, Mr. Chairman.